It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are, or what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence, and it's certainly not a 702 hearing. It is only one thing, a probable cause hearing. That's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial, as well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period. The next stage in understanding whether or not a continuance is necessary is, one, understanding the purpose, the limited purpose. Two is, what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants to present, is that going to affect the probable cause determination, right? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. And I think the same analysis applies here. Listen to the evidence first, then you ask the defense, well, what are you going to present, and will it be necessary, will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing. There's really four categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming on to campus at about 7 a.m., or I think about 8 a.m., okay? It's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They capture his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon t-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs to the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence, is the video surveillance that shows the defendant on campus taking the shot. The second point is circumstantial evidence tying him to the rifle. Right? In that wooded area, police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds. And these are 30-06 Remington rounds that one has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, there's a search warrant that's executed on his house. In that house, police find a Dremel tool, and they also find the same make and model of ammunition, Remington 30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says, test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions. The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Cook, and I took it, right? This note was written before he left St. George and came to Orem, and was left in his apartment. His roommate finds it, roommate/lover finds it, and this initiates a text message conversation back and forth between the lover and the defendant, where the defendant says, yeah, I shot Charlie Kirk, and I'm summarizing, shot Charlie Kirk, I left the rifle behind, I had to leave the rifle behind, but I'm going to pick it up and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey guys, it was me, I did it, thanks for all the good times, goodbye. And the final confession is an acquaintance, is a former law enforcement officer, and he helps arrange the defendant turning himself into the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right, so there are three categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The fourth category of evidence is that DNA evidence, and you have to understand what that DNA evidence is. The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires.